As Sandy mentioned, this is a warranty law, and it requires existence of an express warranty. Now, all auto manufacturers, to my knowledge, issue a warranty with the vehicles. So, if there were such a thing as a car being sold without a warranty, then the law would not be effective to that car. But that's not the case. So, it is a warranty law, and all cars come with warranties. Now, the parties in an arbitration in a new car lemon law are the consumer and the manufacturer. Even though the consumer doesn't deal directly with the manufacturer, he deals with a dealer, an auto dealer. The dealer are the franchisees or owned sometimes by the manufacturer, and it's his representative or its representative that you deal with. So all your dealings, the way you purchase a car is through an auto dealer, but the party you take to arbitration is the manufacturer of the vehicle. Now, for a new car, the definition is, as we mentioned earlier, it's got to be within 2 years. So if, let's say, it was sold and resold, the dealer bought it back, the guy wanted a new car every year, and after 1 year he sold his new car back to the dealer, and the dealer now resells that car. It's only 1 year since it was first issued, and it didn't have 18,000 miles. It's still called a new car. And the second buyer will get the benefit of the new car lemon law. So any car less than 2 years old, or it should be an and, if it's less than 18,000 miles, it's got to be any one of those components will kick it over and make it subject to the new car lemon law. And if it's not subject to the new car lemon law, it may very well be subject to the used car lemon law, which we'll discuss shortly. But it can't be both. It's either new or used, and it's mutually exclusive. The definition of a motor vehicle is something that's purchased or registered in New York. It may be leased in New York, but it's got some contact to New York. If it was purchased out of state, in Connecticut, in New Jersey, but the consumer registers it in New York, it is covered by the New York lemon law. Now, sometimes a person buys a van, it has a conversion van. Conversion vans, those vans sometimes are made, custom made for certain situations. It can provide for wheelchairs, or it can provide for other accoutrements that may be necessary. So it depends how that is sold. Is the conversion van first converted before it's sold to the consumer? Or does the consumer purchase the van and then it's sent off to be converted? That will make a difference as to what type of warranty he gets. Usually, the conversion company, very often you have the manufacturer has the chassis, the body, and the dealer then sends a number of those vans to be converted so that he has a market for those converted vans, and he gets a separate warranty from the converter, which is a different company than the manufacturer. Now, we mentioned earlier that it's got to be less than 18,000 miles on the car, or within 2 years. Now, a motorhome is also covered by the New York lemon law, and it has its special rules, which we'll get to shortly. But it is something which can be receive the benefit of the new car lemon law. Now, off-road vehicles, as Sandy mentioned, the snowmobiles and farm equipment or so on, is not covered by the new car lemon law. Farm equipment like tractors, combines, things of that sort, have its own law, actually. There is a relatively new law, a few years old. It's 697 of the General Business Law, which deals with if you buy a farm equipment, which normally is not on the roads, but it can be on the roads, and it has its own warranty law. But not its arbitration. It does not yet have arbitration program. Now, we mentioned primarily. Primarily, as we said, it's 51%. It's more than half. It's got to be more than half for personal use. You cannot use the car for business use and then claim the new car lemon law. There is a statute in the legislature now trying to expand the coverage of the new car lemon law to include commercial vehicles, but as we speak, it is not yet law, and I doubt it will become law. And it is now a consumer law meant for personal use only. Now, the relief under the new car lemon law, there are two types of relief you can get. You can get a refund or a replacement vehicle. And the replacement vehicle, as Sandy mentioned also, is a comparable car, the car that you're turning in. Now, very often, the dealer or the manufacturer uses this as an opportunity to put you into another vehicle of its own manufacturer. And usually an updated model. If you have a 2-year-old car, which you went through the lemon law program, and you were successful, it's the lemon, the car, the dealer took the car back. Now, you want a replacement. You like the car essentially, except for the problem it had, and you want another car. So that very often the dealer will give you a deal. He'll say, I'll give you the new car, the later model, 2 years younger than the one you had, and all you pay is the difference between what you paid for the old car and the price of the new car. So that may be one way of going about getting a replacement vehicle. Now, unlike other states, New York does not have a last chance repair effort. Many states do that, do require that. They, let's say, like 3 repairs, and then you got to give the dealer another chance, the manufacturer another chance to repair the vehicle. That's not so. Once you qualify for lemon law relief, you have the 4 times necessary for the used car. You went 4 times back for the same problem, and after the 4th time, the problem still exists, even though it was subsequently repaired. You are eligible for lemon law relief. And as we mentioned, cannot collect any incidental damages, and therefore towing fees, rental fees, repair costs, lost wages, insurance, all these things are not recoverable under the lemon law. Now, how do you qualify? The consumer, to qualify for lemon law relief, he has to show one of 2 things. One, he had a reasonable number of repair attempts within the warranty period. What does that mean? Well, reasonable is, there's a presumption, as we went into before. The presumption is if you go back 4 times for the same problem, that's a reasonable number of attempts. The legislature has spoken that 4 times is considered reasonable. Is 3 times reasonable? Maybe, maybe not. That's, again, something which you'd have to rebut the presumption. If you do not have 4 times, you only went back 3 times, or 2 times even, but you want to argue that's reasonable under the circumstances, you can argue that. It's up to the arbitrator to determine under the totality of the circumstances whether it is in fact reasonable. The other way to qualify, besides having the reasonable number of repair attempts or a timeout, again, reasonable number of repair attempts could be 4 times, or it could be 30 days in the shop. But there is, besides that, if you don't have any repair attempts, you have a problem and you go to the dealer, and the dealer doesn't want to hear from you. He doesn't want to speak to you. He doesn't want to give you an appointment. He just doesn't want to know from anything about you or your car. That's a refusal to repair. It only works really the way we read the law is on the first attempt. If you can't get into the door, and the dealer is trying to delay and stall so that the warranty period lapses before you have an opportunity to take advantage of it, that's called refusal to repair, and you can come in under that alone. But you have to go through, there's certain steps that you have to show, that you have to give notice. You have to give notice to the manufacturer and return written notice, and then he has a certain amount of days, 20 days and so on, to comply. Very few of the applications we see, and that you will see, that will come before you, will be based on the refusal to repair. Because although some people try to use that as an argument when they say they went to the dealer fixed the car, they went back again, because the problem reoccurred, and they went back again, and after the 2nd time the dealer repaired the car, and then it happened the 3rd time, and then they went back, and this time the dealer says no more. There's nothing wrong with the car. It's your imagination. That's not a refusal to repair, and does not come under the refusal. It does qualify as an attempt to repair. So if the dealer refuses to see you again on the 3rd time or the 4th time, then that can be deemed an attempt to repair, and you qualify with the first 2 actual repairs plus 2 attempts to repair will qualify you for the 4 repair attempts that you need to qualify for the relief. Okay, even again, the last line is critical here. Even if the car is repaired, it may have been repaired on the 8th time, or the 6th time, or the 5th time. It's irrelevant. It's irrelevant to the arbitrator. If you find that after 4 times the problem still was substantial and it still continued to exist after 4 attempts, then the person qualifies, even though by the time you get to arbitration, the car is in perfect shape. As we mentioned, there's a rebuttal. That's only a presumption. 4 times or 30 days is a presumption. It can be rebutted, and that would depend on the circumstances. Either way, either the manufacturer can argue that I need more time. 4 times is not reasonable under the circumstances. It's a very complex problem. Or the consumer can argue that even 3 times or 2 times is reasonable under the circumstances. And it will be for the arbitrator to determine if that's reasonable. Refusal to repair, here are the details. You have to give, after 7 days, you can't get into the door, then you have to notify in writing the manufacturer with a return by mail, certified mail, return receipt requested. He has 20 days then to get to you to start making the repair attempt. Now, as mentioned earlier, there are two defenses that a manufacturer can raise. The first is, it doesn't substantially repair. It's critical. It's trivial. It's not an issue which should qualify for the extreme relief of refund or replacement. It's not substantially. It does not substantially impair the value. That's one defense. A guy, you know, he didn't like he had a paint problem, and the paint problem, it was repainted, and didn't like the tone didn't match with all of it. It may be the arbitrator may find that, you know, it was repainted, it was good, but it's not exactly the same as the original. It may not be substantial. It will be up to the arbitrator to determine if that's substantial or not. Abuse, neglect, or modification speaks for itself. If the dealer or the manufacturer can argue and demonstrate that the consumer abused the vehicle, he never maintained it, never changed the oil, the stalling came as a result of his reckless driving or whatever, or poor maintenance. If he can demonstrate that, then it's not necessarily the problem of the car, but of the driver. How do you calculate a refund? The best thing is what you pay is what you should get back. Now, the purchase price, sometimes, very often, consumers have a car to trade in, and when they buy a new car. So how do you calculate the trade-in? Now, there's a very something which you would not notice unless you are brought to your attention. The trade-in value that a dealer puts on the invoice, he's going to give you, let's say, $5,000 for your 1982 Buick or whatever it was, which was a piece of junk. I mean, it was worth nothing. But he's going to give you $5,000 for it towards the purchase of your new car. The statute says that if you go through lemon law and are entitled to a refund and you want to get back the trade-in, that the value you get for the trade-in is based on the NADA book value or some other official way of valuing the car and wholesale purchase price, not the retail purchase price. So you have to look in the book to see how much you get for that car, which probably be almost nothing, if anything, for that car. Even though you were credited allegedly with $5,000, you will not get $5,000 necessarily back as part of the refund. If the car is damaged by the time you get to return the car, you have to deduct for that. It's not the manufacturer's responsibility that the car was subject to damage before you returned it. As far as sales tax is concerned, that is something the consumer applies directly to the New York State Sales Tax Department. They have a procedure form and procedure to give you that back. The arbitrator should note it on the decision forms, as you'll see, but the actual return of that money of the sales tax is not done by the manufacturer, but by the New York State Sales Tax Department. There is no compensation for any other damages that you may have suffered under the lemon law. You may have other bases, other causes of action which you may want to pursue in small claims court or otherwise, or the consumer may want to pursue. But it's not part of the lemon law, and it's not, you're not entitled to make any award based on other damages. Now, if you lease or finance the car, which means, if you finance the car, means you borrowed money to pay for the car. Now, if you borrowed money to pay for the car, you're paying interest to the lender in order to get that money to purchase the car. The manufacturer is not interested in how you got the money to pay for the car. The fact that you took out a loan is of no consequence to the manufacturer. The manufacturer is only responsible to repay, to refund that which is the price of the car which you paid. The fact that you spent more money for interest is your own expense and not recoverable under the lemon law. Similarly with leasing, there's a whole different concept for leasing. What you do under a lease is you do not own the car. And the parties really with a lease are three parties involved. There's the consumer and the manufacturer, but there's also the leasing company, which technically owns the vehicle. The consumer is the lessee, the one who leases the vehicle, and he has rights to register the car. And his interest in that vehicle is only based on his monthly payments during the term of the lease, or whatever down payments he made. So he's going to get, there is a whole formula as to how to calculate the refund for a lease, on the lease, and then the statute defines it. It's in your books. I won't take time now to go. You're just going to forget it anyway. So I urge you, after you leave today, to, at your leisure and when you have time and to focus, read the books very carefully, the guides. It will give you all the information you need, how to calculate the refunds and so on. Now, as for motorhomes, I mentioned to you earlier, it has its own set of rules. Now, motorhomes are just what it says, a home on wheels, a motorhome, and therefore it's a much larger purchase. It's usually runs, hundreds of thousands of dollars. Now, they have a special Bill of Rights and a different standard. Instead of the 4 times or 30 days out, it's 3 times or 30 days. And there is a last chance repair. So that after 2 times, you have to notify the manufacturer of the motorhome and give him an opportunity, and the notice has to be in writing with return receipt requested and the whole works, and give the manufacturer an opportunity to make sure that they know that one more time, and they're going to be responsible to pay back a hunk of money. So they're going to take this very seriously. So you have to make sure that you follow the procedure, or the consumer has to make, I keep on saying you. You're all maybe purchasers, but you're now in the function of arbitrators. So when I say you, I meant the consumer. The consumer has to make sure to follow the procedure very carefully so in order to entitle that consumer for a repair, refund, or replacement. So again, the main difference between the motorhome and the vehicle is that you won't count that last attempt until a proper notice was sent. It may take a while if you don't qualify. If you may have 4 or 5 attempts, but no more than the first 2 attempts are counted, and then the 3rd attempt is not counted until, even though there may have been many more attempts, until the manufacturer gets proper notice. Now, what does the consumer do if he feels that he has purchased a lemon? He can go to court if he wants. He can go to an arbitration program. Some manufacturers have their own arbitration program. But I doubt any today, really, those arbitration programs that are run specifically by the arbitrators, by the manufacturers, I don't think they qualify or comply with the strict requirements of the federal law. And therefore, if they don't require they follow the law exactly, then they're not binding, and you can come into another arbitration such as ours, the state-run arbitration, and you can go through it again. The fact that you went through the the manufacturer's program will not prohibit you from going through this program, the state-run program, and you know, the fact that there was a decision rendered in the earlier arbitration program can be taken into consideration, but it'll be given whatever weight you, the arbitrator, feel that it deserves. Now, the consumer must act whichever way he goes, either to court or to arbitration, within 4 years of the purchase date, when he purchased the vehicle, and that's the statute of limitations under the lemon law, both for all lemon laws. All right, I just concluded a basic outline, a very rough general outline of the new car lemon law. Now, the used car lemon law, it's again, it's 190. It's a separate section. It's the next section in the general business law. It's 198B, and it was enacted in 1984, but amended in '89 to provide for arbitration, which started operations in 1990. So now we're, what, 24 years into it. Now, the main difference with the used car lemon law is the used car lemon law is very problematic. We have been trying for many, many years to amend the statute because we find it totally inadequate. It is a little, I said little, but of far less use than we would have hoped. Most people who apply under the used car lemon law do not qualify. They cannot come in because they don't meet the standards. The standards, the window of opportunity where the warranty, what we call the warranty period for a used car, is so small that it precludes 3/4 of the people who apply. And what do I mean by that? I'll show you in a second. But at first, just to distinguish between the new car and the used car, your parties are different. You're not dealing with the manufacturer anymore. You're dealing with a used car dealer. The used car dealer is the party that the consumer has a dispute with in arbitration or in court under the used car lemon law. It's not the manufacturer. Now, again, what is a used car? Anything over 18,000 miles or 2 years, whichever is first. If the car is a brand new car, but it's got more than 18,000 miles, it's a used car. If it's got more than 2 years but hardly any miles on the car, it's a used car. You have to pay at least $1,500 for the car to qualify. And now this has also become problematic with the lately, most vehicles now, most manufacturers make cars a little bit better so they last more than 100,000 miles. But it only goes up to 100,000 miles at the time of purchase. So if you buy the car with 101,000 miles, there's no used car coverage. And again, it's also has to be more than, primarily for personal use and household purposes, so it's more than 50% for personal use. It too includes motorcycles. It didn't originally. It was amended to include motorcycles. There are no motorhomes in the used car. For some reason, I don't know why, but used motorhomes are not covered. And once you go out of the new car range, you're on your own. You have to rely on regular warranty law. Now, there are some exclusions. You have, again, what's a dealer? A dealer is someone who sold a car more than 3 times before this purchase. Now, this has to be at least the 4th purchase within the last 12 months to qualify as a used car dealer. There are businesses that sell cars, that lease cars, and then sell them after lease. Some of them don't qualify. For instance, banks, financial institutions do not qualify under they are not used car dealers, even though they may sell more than 4 cars of their own stock, of their own inventory. If a person, a lessor, a leasing company, wants to sell it to the lessee who leased it, they won't have that coverage anymore because the leasing company, if you lease to a consumer, that consumer had new car coverage at the time the lease was transacted. And now, at the end of the lease, 3 years, 2, 3, 4 years later, whenever the lease is terminated, now the leasing company sells it to the consumer, to the same consumer. The consumer wants to buy that car. he's not going to get, again, a coverage under this because of the transaction under the used car lemon law. It's specifically excluded. Governments are not also do not constitute dealers. Yes?
So
First question.
on the intake, do they decide like whether you have arbitration jurisdiction, like whether the institution qualifies?
Yeah, I'll get to that later. All applications for lemon law under the arbitration program go through the Attorney General's office first. They must go through the Attorney General's office. What the Attorney General's office does is reviews each application on its face to determine whether everything was filled out properly and whether they qualify on the face. An example, if it's more than 100,000 miles on a used car, we'll reject it on its face. It's not that we're going to question whether the consumer is right or the manufacturer is right, but just if the facts do not fit into the four corners of the definition, we will reject it. And we will tell the consumer why we're rejecting it. Sometimes the consumer can correct the problem. For example, he didn't have it 4 times. We'll reject it. So he'll come back another time after the 4th attempt, and he'll come back again. Or he didn't provide certain information, and he'll come back. But if it's over 100,000 miles, there's no way to come back. He's out of the box. Now, this is the point why this used car lemon law is insufficient and inadequate. Because the window period, what we call the warranty period, the time when the consumer has to act, is so short, so small. The best of the 3 warranties which are in effect now under the law is for the youngest cars, the newest cars. That is any car between more than 18,000 miles, because under 18,000 it could be a new car. If it's greater than 18,000 miles to 36,000 miles, it gets the largest warranty. What's that? 90 days. 90 days, 3 months, that's all you get. Or 4,000 miles. So the consumer has that short period of 90 days or 4,000 miles, whichever is sooner. He drives a lot, then we can do it in 1 week. To go back the 3 times necessary under the used car, or to have 15 days in the shop in that time frame. Most people can't make it, can't qualify. And that's why 3/4 of those who apply don't come in. Yes?
Herb, if you're saying that it's not satisfactory as it is, what is the Attorney General's office doing to...
We have made a number of attempts to try to expand the duration of these warranties. And the legislature doesn't want to do it. The industry is very, very powerful. The used car industry, the whole, all the dealer associations and so on, they fight it tooth and nail. So far, we have not been successful in trying to expand these warranties.
How large a population of dealers like this are there? Thousands?
I mean, every used car, you go down Fordham Road or in Queens Boulevard or wherever they said there's a slew of them. Every block you have 2 or 3 used car dealers. The second best warranty is for those cars between greater than 36,000 up to 80,000, less than 80,000 miles. Then you have 60 days. 60 days, 2 months, that's all you have. Or 3,000 miles. And then last, the least long warranty is for the oldest cars between 80,000 to 100,000 miles at the time of purchase. All it has is 30 days or 1,000 miles. So you can understand how difficult it is for consumers to qualify under the used car lemon law. And that's why we have so many fewer cases under the used car lemon law than we do under the new. Now, there is a way to extend the warranty somewhat. Now, anytime it's in for repairs, the clock stops. You don't have to count those days. If it says 4 or 5 days in the shop for repair, that will be added on to your warranty after, just like stop and then continue again after you pick up the car. So you may get a few more days out of that. Now, again, I just should say that I forgot to mention with the new car lemon also, even if you don't qualify for the relief of a refund or replacement on the new car or used car, the fact that you reported it first within the warranty period entitles you to get repairs under the lemon law for the car, for the problem you're brought to the attention of the dealer at no cost, even if it goes beyond the warranty period. You may not qualify for the relief or the refund, but you do, once you get that in the first time, reporting a problem to the dealer, then he has to take care of that problem. Now, another very major distinction between the used car lemon law and the new car lemon law. The new car lemon law, we said, was a warranty law, whatever the manufacturer gives you, usually bumper to bumper coverage. Used car lemon law is based on covered parts. It's only those parts listed in the statute which are covered and are subject to the used car. And those are the only parts that you can complain about. Now, for instance, there are the major parts, but again, this is another aspect of the statute which is outdated in essence. It was written many years ago, and in the meantime, most of our cars are technologically advanced. Right? There are chips, there are no kinds of computer things, and that wasn't taken into consideration with many of these problems. We had an attempt to change some of it to systems as opposed to parts. So that way, at least, whatever is considered in the engine system, even if it includes certain more technologically advanced parts. But here you have a list of those parts which are covered, and only those parts are covered. Now, for example, air conditioning. It's a very important part of the vehicle, but it's not covered under the used car lemon law. Now, a dealer can issue a warranty which excludes, and they all do because they have a standard form they give out just to protect themselves. They can exclude certain situations so that you can't come under the used car lemon law. It'll just negate your used car protections. And that they're mostly are very logical and very understandable. If you don't maintain the car properly, if that's another thing. If the odometer stops or is stopped, they will not. Then you can't prove when you went in. If you were within the guidelines, if you went in within the warranty period, you were 3 times what the mileage was. If you don't have the mileage recorded, there's no way of telling. So you're out of the box. If the odometer is not working, you will not be eligible for a used car protection. If you tow the car when you're not supposed to, it's not strong enough to tow and cause problems. If you hire it, if you use it for hire, a cab or so on, again, it disqualifies your protections. Now, again, similar to the new car lemon law. How do you qualify? How does the consumer qualify for relief? Well, again, it's a reasonable number of repair attempts. And the statute defines what is reasonable. There are 2 tests, again, for what constitutes reasonableness. A little bit different. Instead of the 4 times and 30 days under the new car law, it's 3 times and 15 days under the used car lemon law. Again, the rationale is because the used cars are older cars, they don't work so much as well, and they're not as expensive, so the standards are shifting. Now again, if the dealer says, well, I don't have the parts. Okay, you don't have the parts. You have to get them within a reasonable time. The statute allows you up to 45 days, no more, to get, if you don't claim that there are no parts available. And again, the fact that the car may be repaired is of no consequence when it comes to arbitration if you qualify before then. Again, affirmative defenses, same affirmative defenses we had in the new car. It does not substantially impair the value of the car. Or abuse, neglect. Or you modified the vehicle, you souped it up, you did something to the car, and then you lose out on your protection. And the similar relief as we had under the new car lemon law, it's refund or replacement. Again, the replacement is a comparable car. You go to the dealer, you want the same 2005, I don't know, give me a car, Camry that you had, that was 11. And probably, if you go to a used car dealer, they probably could get such a vehicle more likely, more easily than the new car can get, new car dealer could get. Again, very important, there's no, except for as I told you, the only time we had it was by the motorhomes with a new car, There is no last chance repair. There's no time to, okay, now I'll tell the dealer says, okay, give me one more chance. I'll repair it now. Nothing doing. Once you qualify, and there is no second bite. And again, there's no incidental or consequential damages. The fact that you had to spend money to get the car towed, or you lost time from work, that's not covered under the used car lemon law. Now, another major difference. There is no mileage deduction under the used car lemon law. Not yet, anyway, although there have been attempts by the industry to get that, to get some mileage deduction for use. There is no mileage deduction, so the consumer is entitled to the full purchase price back in the event the car is deemed to be a lemon. Again, okay, now for a service contract, many times a dealer will try to sell a customer a service contract for money, excess money. A warranty is where it comes with the item, with the vehicle, and you don't pay extra for it. A service contract is something which you do pay for, and it's extra protection. It's a side item, and it's not necessarily part of the vehicle. So in the event the consumer is successful and you want to find for the consumer, that purchase price for the service contract would not be refundable under the lemon law. And again, if you made some adjustments up or down, you may improve the car, or you put something on the car which now devalued it, you'd have to make the adjustment when making the refunds. Now, another important point is that the consumer has to provide the car lien-free. Lien-free means you paid off your loans. There is no lien on that car. In order for the dealer to be responsible and pay off the award, the arbitration award, you have to show that the car is lien-free. And if the money that comes back from the refund is not sufficient to pay off the loan, you have to make sure that you pay off the loan before you get your refund, and you have 30 days to do it. So if the consumer does not do that within the 30 days and provide a lien-free car, the dealer is no longer obligated to make that refund. Now, it's not relevant to the arbitrators, but if it's a lease and it's found to be a lemon, that lease terminates. There's no early termination fee that can be assessed. Now, we have this program that you are being part of is based on regulations which were formulated by the Attorney General's office, and they're attached to your guides. They were adopted under the State Administrative Procedures Act and followed the necessary steps so that this arbitration is mandatory and binding. So the dealer has no choice. If the consumer files an application, the dealer must participate or default. And the same thing with the new car, with the manufacturer. It is mandatory and it's binding, so that either side must comply with the arbitrator's award. As Sandy mentioned, it's very important, we'll go through it in a moment, how important it is when you issue your awards or decisions that you fill out the forms very carefully and make a finding of fact, summary of evidence, conclusions. They're all critical to the legality of the program and the validity of the award. Now, as I mentioned to you briefly before, what the process is that when a consumer files an application, it goes to the Attorney General's office. We review it superficially, so that facially at least it complies with all the requirements, and either we accept or reject. We notify the consumer, and if we accept it, goes on to NYSDRA, to the New York State Dispute Resolution Association, who then solicits the consumer for a fee. Once the fee is received, then the NYSDRA then doles out the case to the appropriate regional office, or wherever it goes, and an arbitrator is assigned, and a date set for the hearing is made. Now, there's again, the step process, again, doesn't pertain so much to the arbitrators, so we'll go on. Now, the hearing it should be scheduled within 35 days from the time the fee was received by the NYSDRA. Now, and the decision should happen within 40 days from the time of the filing date. In other words, there are 5 days between the hearing and the time that the arbitrators are supposed to issue their decision. This, I'm sure, Steve will cover in detail. We have attempted to make life easy for you. And what we did is prepare separate decision forms, which you will, I guess, I don't know how you're going to get to see them, but in case after the hearing and review of the evidence, you determine that you want to issue a decision in favor of the consumer for a refund. We have a form that's especially for that purpose, and all it needs is to follow the steps. Okay, so you'll see that the first section after filling out the name of the dealer and so on is a summary of issues in dispute. And they're supposed to be check boxes. That's all you have to do there. Depending what the issues are in dispute. We give you a list of 7, and number 8 is other. So you have an opportunity to fill something else in if there is another issue which we didn't cover. And they have the standard ones that whether the vehicle is primarily used for personal use, whether that may be in dispute. Whether the problem was covered by the used car, maybe it's not covered by the used car lemon law for whatever reason. It may be a new car. They argue. Where there are 3 attempts, I'm looking at the. This is the used car, so it's going 3 attempts. The new car will have 1 for 4 attempts. Did the problem exist after the 3rd attempt? If it didn't exist after the 3rd attempt, then you didn't qualify for 3 after 3 attempts that the problem is still there, and so on. Now, very important, as Sandy mentioned and tried to emphasize, summary of evidence. It's a blank page. All it says here is consumer, dealer, and lessor, if there is one. So you're given the opportunity to summarize the evidence that each side produces, either by documents or they testify, or they have witnesses. Whatever else they produce should be summarized. And after you have your summary of evidence, you have the arbitrator findings. Arbitrator findings should parallel this issues in dispute. If there were 1 or 2 boxes were checked as issues of dispute, you have to be sure that your findings are on those issues of dispute. Otherwise, there is no sync here. It doesn't match. It won't be rational. So we have a catch-all that says that you qualified, the consumer qualifies, and that's basically there were 3 or more repair attempts for the same problem within the applicable warranty period, and the problem continued to exist at the end of the 3rd period. That includes about 4 or 5 of the issues in dispute up front in one check here. And again, and then it has a basis for your conclusion that based on that, since you determined that there is a lemon here, and the consumer should be successful, then there's a way to figure out line by line, just put in the numbers as appropriate, how to calculate the refund. And of course, it has to be signed. The same type of decision process is if you want to find on behalf of the dealer. And we did it so the questions are in reverse. The findings are reversed. We did not find that there were 3 times. We did not find that there were that it was subject to the lemon law and so on, that it was not subject. Here, for instance, the issue of dispute will be the same. Summary of evidence will be the same. But under the findings, you have almost 8 different findings. Number 1, the vehicle is not primarily used for personal, family, or household purposes. That may have been the issue of dispute, and you find not, so that's the reason why you're going to rule on behalf of the dealer. And so on for each item that is appropriate. You should make sure after you finish that you responded to each one of those that you listed on the front that there is an issue in dispute. Yes?
Just as it was mentioned earlier that the claimant can amend the complaint once they come in to some degree, can they amend the award sought, can they change, once they come in, do they do that in the initial form and decide whether in the event they win, they want a replacement or?
Yes, the application form, which a consumer completes, and which you will get as part of the file. You will get the initial application form and any attachments, any document, work orders, and so on, which the consumer chose to include, right? And that's what's being sent also to the other side, to the other party, either the manufacturer in the new car program, the dealer in the used car program. You will get to see this application form, and will be asked to elicit his response to the application. And you will get a copy of that as well, as will the consumer. And the consumer then has an opportunity to respond. To your question, can they, see, they initially, in part of the application form, as you will see, is where do you want this, and what type of relief do you want? There's a region that they check where they want this arbitration to take place, so they choose initially which part of the state and which office they want it to be held, the hearing. Whether the hearing should be oral or on documents only, which I'm sure Steve will discuss. The inference is always orally unless they ask for in documents. And if successful, I wish to receive full refund box or replacement, comparable replacement car box. And they have to check one or the other.
Yes.
And that can be changed.
It can be changed. Yes,
it can be changed. Up till the hearing, it can be changed. Even after the hearing, if it warranted, it could be changed. There may be a realization that they won't get a comparable vehicle, and they'll switch to refund.
Right, but if they want the refund, you've got to calculate the refund then and there, so they have to have...
Not then and there, you have 5 days.
So they could submit, no, not then and there, but I mean, you have to have the documentation for the refund there. They can't submit it later.
If you feel that you are missing any documents which will enable you to render a decision, and you're not sure, let's say, which way you want to go yet, and there's some document that you feel is necessary, a certain work order or something, you can ask that the sides produce it, the appropriate side. If it's a work order, you assume you would ask the dealer to produce it to you in a certain time frame, and you will hold off issuing your decision until you get that. Or if you need information to calculate a refund, for example, in the leasing situation, it's more complicated. They have to provide information as to how much was given to you, how much was paid, what the interest and so on was. That sheet of information should be forwarded to you before the hearing or at the hearing. If not, then you will get it afterwards, and you can't issue you may not be able to issue a refund, an award with a refund until you get that. So you may have to
hold it. If you don't have it at the time of the hearing, the other side doesn't get a rebuttal on it.
On rebuttal on what?
On whatever you're, like if you ask for something that's missing, and it comes in after the hearing, it's time for you to consider it for your decision, the other party there doesn't have any rebuttal opportunity.
Well, any document that comes in to be considered, the other side gets a copy of it. If it's the consumer sending a copy or the dealer sending a copy, the other party is entitled to see that document.
They won't be able to question
Yes, he will. She's referring to the fact that there may be additional documents coming in, which not necessarily go to the calculations, which the other side may want to dispute. They will be notified that they have a certain amount of time, short time, to respond to that document and issue whatever comment they want about it.
So this would
Is that what you're asking?
This would all go through the AG?
Yeah, no, not through the AG, through the NYSDRA.
Goes through NYSDRA, and then NYSDRA has to forward everything.
Right, NYSDRA will tell the arbitrator, once you ask for a certain piece of information, or at the hearing you may have, before you close the hearing, you may say, please forward this information to NYSDRA, because I need that in order to render a decision. So when it comes in, they will give it to you, and then you will decide what to do with it.
Will that extend you that 5 days then, you have to respond? If you're getting new documentation, is that...
There will be a short line, I don't know what the procedure is. 5 days the other side gets? Maybe 5 days. Okay. Now, what happens after the decision is issued? Either side has an opportunity to seek a modification, and that has to be done within 20 days. That's again, modification. That again is based on the CPLR Article 75, which provides for the time frames to seek modification or appeal later on. Again, if you want to vacate or challenge the award, that's 90 days. And that has to be done in court. That's not done by the arbitrator. The modification request can be done directly to the arbitrator, but it's limited as to what it contains. It's only really based for typographical type of things, you know, you forgot something, you forgot the tax, or you miss, the numbers were inverted or something like that, or the type, you know, some not consequential issue which is subject to modification. If you want to re-argue the case, that's more difficult. And that, I think, would require probably a motion to vacate or challenge the award, and not through modification. But again, it depends. If you know, just if you want to be safe, you can the consumer. I would recommend the consumer make a request for modification. Worst comes to worst, the arbitrator says this is not subject to modification, and deny it, and the consumer still has an opportunity to go to court to challenge the award. And again, he has 1 year, the consumer has 1 year, or either party has 1 year to confirm the award. I don't know why anyone other than the consumer would try to do that, but the consumer has that 1 year to confirm award. Confirm award means you take it to court and confirm it, convert it to a judgment. And that's collectible like any other judgment. Now, if the dealer or manufacturer delay in complying, there is a small penalty provision in law, which is not very useful, but it gives the consumer an extra $25 a day, up to 20 days, I guess. It's up to $500, which you can add on if the dealer or manufacturer delays in complying with the award. There's a world of knowledge that can be gleaned from the application, the form application submitted by the consumer for arbitration. It tells you the date of delivery of the vehicle, the initial mileage. All is critical is to determine whether it qualifies, whether it was purchased in New York or registered in New York. All that is asked in the application form. How it's used, was it primarily used for personal use or not? Again, they may lie, but if they check off personal use, that's all the Attorney General's office needs to know in order to send it on further. The other side may challenge that, and the arbitrator will have to determine whether it's true or not. Again, all these pieces of information which are critical in determining whether they qualify for arbitration. We try to gear the form to what you want to use it for. There's a different form for each type of result you want to reach to make it easier for you. Again, this is something which there's no use going into how to calculate the lease refund, but bear in mind the statute has a definition of lease price and what it entails and what it includes, and I ask that you, if you have that problem, have that issue for me, review it in your guide. It will instruct you exactly how to proceed line by line. Now, again, as I mentioned, if you have a decision for the manufacturer or dealer, it will say that it did not qualify. And we also have such a thing as a decision reflecting settlement. Many times, the parties will try to settle the case, usually initiated by the manufacturer or the dealer to get rid of the case. And they will attempt to work out some kind of a deal which is satisfactory to the consumer as well. But very often the consumer, and sometimes the dealer or manufacturer may be a little suspect that the other side may not live up to their obligations, and they want to put it in writing, the settlement. So there is such a thing as a decision reflecting settlement, which could be anything, any terms that they agree upon, and that constitutes a settlement, and doesn't have to necessarily stay within the strict confines of what the law would provide. Although most of these cases do end up in settlement and do not reach the arbitrator, and the arbitrator is not asked to issue render a decision on it, this may change. We're talking about the excess wear and tear damage clause, which under leasing, specifically on this part of the personal property law. It's the Motor Vehicle Retail Leasing Act, which was amended in 1995 to add this provision for arbitration. Now, when you lease a car, you can either go to termination or you can terminate early and surrender the vehicle. In either case, that car may or may not be the victim of damage. There may be substantial damage on that car. And oftentimes, the consumer is very much surprised when he receives a letter in the mail from the leasing company saying, oh, by the way, the car you dropped off had $5,000 worth of damage. Please issue a check immediately. And the consumer is befuddled because, as far as you know, the car was clean. So he has an opportunity now to dispute that claim of damage through arbitration. Now, as I said, you can either, very often, consumers go to term and then either buy the car. Very often they buy the car because it has damage on it and they don't want to be responsible to pay for the excess damage. So they have to purchase it by the residual value of the car. When you sign a lease, you're in essence using the car up to a certain point. So it's partial use of the car. The car has a remaining value after you finish using it. That's called the residual value. And that is less than the purchase price. But it's usually a significant number. And you can, if you wish, if you have the option, most leases now provide an option to the consumer to purchase the vehicle at the end of the lease. They would pay that figure and take the car and keep it. If they don't exercise that option and they choose to return the vehicle, they again are subject to make sure that there's nothing more than normal wear and tear on that car. Now, what is normal wear and tear and what is excessive wear and tear is defined by the lease. And that lease will has to tell you, how many scratches and how deep and how often, how frequent, and all this kind of stuff is spelled out. How the thickness of the tires or the tread of the tires and so on is all spelled out pretty much with particularity in the lease, so that you are put on notice, in essence. No one reads it, but you're put on notice that anything which is not written in that lease that you will be responsible for. Now, a lease doesn't mean a rental. You go out and rent a car and return the car and it's damaged. That's a different issue. That's not covered by this statute. This is lease. Lease means more than 4 months rental. It's got to be greater than 4 months. And also, it's a personal family use. It's not commercial use. And most leases, if not 100% of them, put the responsibility for damage on the lessee, on the consumer. And as I said, it's defined in the lease as to what constitutes acceptable damage or unacceptable damage. Now, there is a procedure that this law sets forth in order to exercise and activate this protection. Usually, a car that's damaged, and at the end of the lease, most leasing companies get rid of the car at auction. They sell it, and they don't bother repairing it. That's their prerogative. They don't have to repair it. But the fact that you damaged the car makes you liable for that damage. But they have to provide an estimate. And there are time frames in which to do that. In contrast, if the consumer wishes to surrender the car before termination, before the termination of the lease, then in order for the leasing company to extract money from the consumer for damages, it has to be actual repairs. They would have to go and fix that car and show the bills for the actual repairs in order to collect that from the consumer. And there are time frames, as you see, when the consumer, that the lessor must provide the consumer with notice that he has these rights. If that's not done, then the whole thing is off the table. The lessor has to tell the consumer at the time he signs the lease that he has these rights, that he has the rights to contest any damage at the end of the lease. And if he doesn't, if the leasing company does not provide that notice, then the leasing company won't be able to take advantage of that. Now, there are times when the consumer returns the car. Usually the leasing company is very quick to turn that car over and get rid of it. But if there's damage claimed, then the leasing company has to hold on to it, so give the consumer a right to have his own appraisal, to question, how does he know to trust the leasing company's guy who says, well, there are $5,000 worth of damage, and he lists 3 pages worth of every nick and dent on the car. He says, that's not so, it wasn't done that way. So he wants to be able to have his independent appraiser look at the car. And the leasing company has to hold on to the car for a reasonable period to allow him to do that. Now, all these things are spelled out in your books. You have a special book, special guide for this separate program. And you will, if it gets to you, which is, as I told you, rare, so far rare, most of the cases settle, even though there are applications filed, and once the application is filed and sent on to the leasing company, the leasing company usually reaches out and tries to work out some kind of a settlement. And more often than not, they do settle. But in the few cases that do go to arbitration, you will be asked to rule as to the reasonableness of the claims, of the damage claims, if they're challenged, and how much they're challenged, and whether the notice is properly sent, and so on. Now, again, we have specific forms, and the application form gives you most information you need to know. They will attach probably the bill that they received from the leasing company and the appraiser if they've gotten their own independent appraisal, and so on. So that's all will be before you. Now, there's not much reason to go into detail beyond that because A, you're not going to have too many of these cases, and B, you'll forget it anyway. So, because they're so rare. So we refer you to the booklets that in the event that you do get a case, you then reread it right before you go and decide that case. Now the last program, which also is very, very small compared to, it's so small, I don't think there were any cases in the last year under this program, right? Not one case. That's the wheelchair lemon law. Initially, it used to be motorized wheelchairs, only those specific types of motorized wheelchairs. But that's changed. The law was amended to include all types of wheelchairs. And there are times when the wheelchairs are lemons. They don't work properly. They don't break. They don't do whatever they do. They don't do what they're supposed to do. So the law was enacted to give the benefit to users and owners of motorized, not motorized, wheelchairs. Now, it used to be 4 attempts within 60 days. Now it's been changed. There's only 3 attempts at repair within 30 days, all within the first year of purchase. Again, it's similar to the lemon law frame. They have the same. You have a guide, you have forms, you have decisions, all similar, very similar to what we've been discussing for the last couple hours. There is a deduction for use as well. It's a formula. You see it there. It depends how long you had the wheelchair, and it depends how much was paid, how much it cost. And you divide it by 1825 is a figure that came up, I think, for, I forget, based on 5 years worth or something. I'm not sure exactly. Now, very often the consumer doesn't pay for this wheelchair. It's funded by a program, either Medicaid or Medicare. In that case, whoever paid the money should get the refund. If the consumer didn't pay, the consumer won't be entitled to it. It'll be Medicare or Medicaid, as is only fair. And that's it.